of a sudden, the door opened, Mick got in, the interior light came on, and I was talking to Jack. And at that moment, I noticed Jack had white gloves on covered with blood.
The allegation that Essex police colluded with and coached Darren Nichols in his account of events. Wombs and Steele's representative, Mr. Bowen, has made numerous submissions which allege that Nichols was coached in his account of events by Essex police. In connection with these submissions, Bowen alleges that the police interviews with Nichols, in which he first gave his account of the night of the murders, were not carried out on the 14th of May 1996 as recorded by police, but at a later date. It is submitted that this backdating alone would demonstrate that this investigation was corrupt and the resulting convictions unsafe. It also leaves open the possibility that there were earlier off-tape meetings with Nichols, in the course which he was coached with a story. The Commission observes that Bowen has provided voluminous arguments in support of his submission that Nichols' interviews were backdated, but the Commission has seen no evidence which supports this serious allegation. The submission remains unsubstantiated speculation and does not give rise to a real possibility that the Court of Appeal would overturn the convictions in this case. The Commission also notes that Nichols was represented by a solicitor, Mr. Craddock, at many of the interviews in question. Mr. Craddock has denied, both in evidence at trial and in his statement to the Commission's Section 19 investigation in 2004, that there was anything improper about Nichols' police interviews. In order for the applicant's allegation about backdating to be correct, Mr. Craddock would have had to have been complicit in any impropriety on the part of Essex police. For the avoidance of doubt, the Commission has discovered no evidence that Nichols' interviews were conducted in any improper manner. Nor has the Commission discovered any evidence that Craddock has been untruthful in his recollections about the interviews. Mr. Bowen has pointed out that Mr. Craddock was a police officer before he was a solicitor, but the Commission does not consider that this makes it any more likely that he has behaved improperly in this case. Nor does it mean that Mr. Craddock cannot be trusted in his account. In support of his submission regarding the alleged backdating of interviews, Mr. Bowen relies on Nichols stating in interview on the 17th of May 1996, someone has been charged with possession of a shotgun. Mr. Bowen points out that Steele was not charged with possession of a shotgun until 2242 on the 17th of May 1996, and so argues that interview 7 must have taken place after this time and has been backdated. The Commission notes that this submission arises from material, namely Mr. Nichols' interview records, which was available at trial, and it could have been utilised in cross-examination of Nichols and his interviewing officers at that stage. In any event, having considered this submission, the Commission takes the view there is no real possibility of it leading to the Court of Appeal to find that the interview transcripts for the 17th of May 1996 were backdated, or there was anything improper about the way Nichols' interviews were conducted by Essex police. In this connection, the Commission notes again that Nichols' solicitor Mr. Craddock was present at all the interviews on the 17th of May 1996. As just explained, Mr. Bowen alleges that Nichols' interviewing officers questioned him off tape. He refers in particular to alleged off-tape discussions on the 16th and 17th of May 1996. This submission arises from cross-referencing Mr. Nichols' custody record for those dates with the transcripts of his police interviews on the 17th of May 1996. These documents were disclosed to the defence at trial, and as pointed out by Mr. Bowen, DC Brown and DC Winston, were cross-examined at trial about off-tape conversations with Nichols. The submission is not new for the Court of Appeal in the absence of exceptional circumstances. In any event, the submission has discovered no evidence that Nichols was ever coached in his account by Essex police. The Commission also notes that Mr. Nichols' solicitor, Mr. Craddock, has stated that as far as he was aware, Mr. Nichols was never coached or spoken to off tape regarding his account of events. However, Mr. Bowen submits Mr. Craddock's statement for the Section 19 investigation actually supports the submission that Nichols was interviewed off tape. Mr. Bowen highlights page 5 of the statement where Craddock describes the interviewing officers asking Mr. Nichols various questions about what mobile telephone he was using at the time of the offences and to whether he was carrying it and to whether it was turned on or off. Mr. Bowen states that such questions do not appear anywhere in the Nichols interview transcripts and that this supports his submission that Mr. Nichols must have been questioned off tape. The Commission does not consider this submission to be correct. In the Commission's view, the line of police questioning, for which appears at page 15 to 21 of the interview transcript for the 17th of May 1996, contains the various questions about what mobile telephone Nichols was carrying at the time of the offences, which are referred to in Mr. Craddock's statement. There is no real possibility, in the Commission's view, that the Court of Appeal would find Mr. Craddock's statement to support the submission that Nichols was spoken to off tape. In any event, Mr. Craddock's Section 19 statement was available to the applicants and to the Court of Appeal in 2006. It was open to the applicants to pursue this point at that stage. In support of the submission that Nichols was spoken to off tape by Essex Police, Mr. Bowen has drawn the Commission's attention to a fact summary of the case against the applicants, faxed on the 22nd of May 1996. This summary refers to details of the events of the 6th of December 1995, obtained from Mr. Nichols, but which do not appear in Nichols' answers during police interview. In particular, Mr. Bowen refers to references to a blue Range Rover and a allegation by Mr. Nichols that Steele had referred to Mr. Worms as an evil cunt when describing the killings. Neither of these points appear in Mr. Nichols' police interviews, which simply refer to a Range Rover and Steele's alleged comment that Mr. Worms was a cold-hearted bastard. Mr. Bowen adds that references to a blue Range Rover do appear in the briefing notes of D.C. Shakespeare on the 16th of May 1996, and that D.C. Shakespeare repeated blue Range Rover when putting Nichols' account to Steele on the 17th of May 1996. Furthermore, according to Mr. Bowen's note, prosecuting counsel John Butcher referred to Nichols' description of a blue Range Rover when summarising the case at the first remand hearing at Chelmsford Magistrates Court on the 18th of May 1996. Mr. Bowen submits that since these words didn't come from Mr. Nichols in the disclosed police interviews, Mr. Nichols must have discussed the case with officers off tape or in recorded interviews which have not been disclosed. Mr. Bowen also points out that the vehicle was referred to as a dark Range Rover in police summary document D56. Mr. Bowen submits that Essex Police attempted to cure these discrepancies over vehicle colour by coaching Nichols to refer to a dark-coloured or blue Range Rover in his witness statement S177A. Mr. Bowen also submits that Essex Police removed the anonymous reference to Steele describing Worms as an evil cunt when the case was summarised in police document D56. Mr. Bowen relies upon the fact that the text in D56 reads as a cold-hearted bastard when suggested that the text has been amended. The fact summary that Mr. Bowen seeks to rely on also appears to be part of the faxed antecedent history of Mr. Steele as provided by Essex Police for the benefit of the prison authorities. This summary would have had no evidential standing whatsoever as opposed to Nichols' account of events as given in police interview and then in evidence at trial. In any event, whilst the discrepancies which Mr. Bowen highlights may indicate that Nichols has been misquoted in the fact summary, this does not necessarily indicate that Nichols gave a conflicting account off tape. The same is true of the reference to the colour of the victim's Range Rover, the colour of the vehicle which was discovered in Workhouse Lane, which would have been well known to the police officers dealing with the case, and the inclusion of the word blue is far more likely to be an error on their part than an indication that Nichols gave further details off tape. In all of the circumstances, the Commission takes the view that Mr. Bowen's submissions on this issue do not give rise to real possibility that the Court of Appeal would find Nichols was spoken to off tape and coached in this account.
you.